Professor Nam-Yong Lee's commentary, long form, a law that punishes only the poor. Can this be called fair? Hello, this is Lee Nam-Yong Professor TV. Today I would like to address head-on a very uncomfortable truth. For those in power and for the conglomerates, the Republic of Korea is nothing short of a paradise on earth. For judges, prosecutors and lawyers, it is virtually a republic run by legal professionals. In any truly just country, the rule of law should fall like an impartial, merciless sword, first and foremost on those with power and great wealth. Yet in today's Korea, the harshest and most distorted version of the law is reserved almost exclusively for the uneducated and the poor. On the surface, we proclaim equality before the law, but in reality, we are operating a system where only the poor are punished twice, 3 times over. In this commentary, I will dissect this structure through the lens of relational philosophy, global standards, and the Federal Enterprise Architecture, FEA, and consider with you how it must be changed. Why do only the poor feel the law? More painfully, when the law broken is the same? First, let us look squarely at the everyday reality we all witness. 2 people commit the same speeding violation. One person swipes a credit card to pay the fine and forgets about it. The other has no money to pay, falls into arrears, accumulates penalty interest, is branded as a credit delinquent, and in the worst case ends up in detention. Formally, the law is the same and the fine is the same, but for one side it is merely an inconvenient cost, while for the other it becomes a bomb that blows up an entire life. At that point it is no longer truly law. It starts to look like a class tax. Second, the same pattern repeats when we look at criminal procedure. Those with money and connections secure competent legal counsel from the investigation stage and carefully prepare favourable statements and supporting evidence. Ordinary citizens and the poor, by contrast, are often so frightened just to step into a police station that they cannot even speak properly, and many do not get a real opportunity to meet a public defender or receive proper legal advice. Under the same charge, it is routine for decisions on indictment, sentencing, and the long-term weight of a criminal record to vary according to how much money and information one has. This is the invisible hand by which power and wealth adjust the real weight of punishment. Third, the public's sense of fairness does not come from sentences written in a statute book, but from the stories of people around them. When people begin to say, the chaebol heir stayed home, wrote a letter of reflection, and that was it, but the man next door went to prison for years for the same crime. Trust in the law and in the judicial system plummets without limit. A law that hits only the poor harder. This is one of the most dangerous fronts in the ongoing war over our system. The rule of law, heaven for the powerful and conglomerates, hell for ordinary people. First, if we look at Korea's rule of law structure through the lens of relational philosophy, those in power and the conglomerates occupy the center of a vast network that spans law, finance, the media, and politics. They stand behind an invisible shield woven from large law firms, accounting firms, PR agencies, lobbyists, and various groups of experts. When the same crime is committed, the outcome is completely different for those inside this shield and those outside it. The law on the books may be the same, but because the relational network is different, the rule of law in practice shows entirely different faces. Second, for judges, prosecutors, and lawyers, Korea is truly a republic run by legal professionals. The more disputes and incidents there are, the larger the market becomes for law firms and legal experts. The more complicated investigations and trials become, the more ordinary citizens are forced to rely on them. The more money and time one can invest in hiring someone who understands the law, the more advantageous one's position becomes, while those who know nothing about the law are placed at a continual disadvantage. Under the banner of the rule of law, a small group of people who speak the language of the law have effectively monopolized the system's vocabulary and grammar. Third, those who wield great power and wealth are precisely the ones who most need a strict, impartial rule of law. Yet in reality, the situation is reversed. The powerful and the conglomerates enjoy a lenient rule of law, while the uneducated and the poor are struck by a cruel and unforgiving one. This is not merely a matter of sentiment, it is the product of a distorted relational network and institutional design. If we fail to correct this deformed form of legal order, Korea will cease to be a liberal democracy and will harden into a paradise on earth for the powerful and the conglomerates, and a living hell for ordinary people and the weak. The dark side of the Republic of Legislation, the Republic of Trials, and the Republic of Lawsuits. First, Korea has become what I would call a Republic of Legislation, IPBop Gonghwaguk. The National Assembly ought to be a legislative body that takes responsibility for the lives of the people. In reality, however, we have entrenched a structure in which interest groups, lobbyists, law firms, and expert networks are deeply involved in the wording of each and every provision. Complex and obscure laws are, in the end, designed in a way that favors those who have the time, resources, and connections to read and interpret them. Law itself ceases to function as a fair rule book for the game, and instead, in too many cases, becomes a custom-made manual for conglomerates and the powerful. This is the dark face of the Republic of Legislation. Second, Korea is a Republic of Trials, Japan Gonghwaguk. Most social conflicts, economic disputes, and even political issues end up in court, waiting for a judge's verdict. The problem is that the trial system is no longer an open public forum accessible to the people. It has become a sanctuary of technical terminology and procedure that only judges, prosecutors, and lawyers can fully understand. The judiciary is one of the three branches of government, but when it begins to feel like a republic of robed elites, ordinary citizens lose faith that justice can be realized through the courts. A republic of trials may be necessary, but a republic of judicial elites is the enemy of democracy. Third, Korea is a republic of lawsuits, Goso Gonghwaguk. When conflict arises, our society tends to reach first for criminal complaints and civil suits, rather than for dialogue or mediation. In politics, filing criminal complaints and accusations against opponents is used as a strategy. Online, defamation and insult laws often function as tools for quietly silencing citizens' voices. Those with money and time wield litigation as a weapon, while the poor begin losing sleep and health from the moment they are sued. When the Republic of Legislation, the Republic of Trials, and the Republic of Lawsuits converge, the system becomes heaven for the powerful, the conglomerates, and the legal elite, and an endless landscape of fatigue and fear for ordinary people and the vulnerable. This is the structure we must break today. How the world is reforming laws that punish only the poor twice over. First, many advanced countries are changing their systems to achieve real equality in fines and punishment. Instead of imposing simple, fixed amount fines, they are shifting towards systems in which fines are calculated in proportion to a person's income and assets. For the same violation, a much larger amount is imposed on those with high incomes to ensure real deterrent effect, while fines for low-income individuals are adjusted to a level they can realistically bear. The paradigm shift here is that fairness is not achieved by the same fine, but by a fine that hurts equally. Second, many countries are expanding alternative measures in place of criminal punishment for minor offences, such as education, community service, addiction treatment and counselling programs. In particular, for young people, the poor, and minorities, the system is being designed to ensure that a single criminal record does not become a lifelong stigma. The purpose of punishment is not simple retribution, but reintegration and restoration. This is the minimal breakwater to prevent the poor from being struck with a second and third blow. Third, world best practices in advanced democracies go beyond equality in legal text and continually monitor inequality in punishment through data and statistics. They disclose and analyze how arrest, indictment, sentencing, imprisonment, and recidivism rates differ by income, race, region, education, and gender, and they check whether the criminal justice system is imposing a disproportionate burden on specific groups. Fairness is not a declaration. It must be demonstrated in numbers and structures, hidden relational networks of punishment and fines, seen through relational philosophy. First, the starting point of relational philosophy is the idea that relationships matter more than objects. A single fine notice or a single judgment of guilt is an object, but behind it lies a complex network of relationships connecting police investigations, prosecutorial decisions, court trials, media coverage, credit records, hiring and firing, family relations, and even physical and mental health. If this network is designed unfairly, then the same fine can be a brief inconvenience for one person and the starting point of total collapse for another. Second, the poor already stand on a fragile relational network. They are entangled in precarious jobs, high rents, irregular income, poor health, and thin social safety nets. In this state, when fines and punishment are imposed, the relational web sustaining their lives can collapse all at once. They lose their jobs, cannot pay their rent, family relationships break down, and their children's education is interrupted. This is not a simple act of punishment, but a form of structural violence that destroys an entire network of relationships. Third, by contrast, the powerful and the conglomerates stand on dense and resilient relational networks. Even in times of crisis, law firms, experts, financial institutions, media outlets, and political connections shield them. For them, the same punishment and the same fine are absorbed and softened by this network, and they are assisted in making a comeback. That is why equality before the law is so often transformed into inequality of outcomes. The reforms required by relational philosophy are clear. We must redesign laws and institutions to restore and protect the relational networks of the poor, redesigning a fair legal, punishment and data architecture through FEA. First, from the perspective of the federal enterprise architecture, punishment, fines, and the judicial system form one vast enterprise architecture. Enforcement, investigation, indictment, trial, sentencing and execution, the imposition of fines, arrears management, correctional measures, social reintegration, and ex post evaluation together form a single business chain. In today's Korea, this chain does not appear before the public as one coherent picture. The police, the prosecution, the courts, corrections, social welfare, and finance all move separately, and the poor have no way of knowing where along this chain and on what basis decisions about them are made. Second, at the level of business architecture, we must explicitly set our goal as ensuring that only the poor are not punished twice over. For minor violations, we should move away from excessive criminal punishment and shift toward education, community service, and counselling as primary responses. Our fine system should be redesigned by combining income-based fines, installment payment plans, and options to convert fines into community service. We must reduce the structure in which arrears automatically lead to detention and instead build processes in which debt restructuring and support for social reintegration come first. Third, at the level of data architecture, the state should regularly analyze and disclose the burden of punishment and fines by income, assets, occupation, region, and education. We must not hide but openly show which class in which region is receiving what kinds of punishment and fines and how heavily. This is the mirror through which we examine the reality of fairness. With an FEA-style data reference model, we must continually check whether the Republic of Legislation, the Republic of Trials, and the Republic of Lawsuits are placing heavier burdens only on the poor. Fourth, at the application and service architecture level, we need AI-based public interest legal platforms. Everyone should be able to use their mobile phone to check and apply in one place for information on criminal and civil procedures, fine installment plans, debt restructuring, free legal aid, and links to welfare services. Above all, legal services must be designed to reach out first to those who do not understand the law, who are weak in digital skills, and who are poor. Such a digital infrastructure must transform a republic run by legal professionals into a legal republic for the people. Fifth, at the level of technical infrastructure, we must introduce AI audit systems so that when punishment is excessively concentrated on particular classes or groups, warning signals are automatically triggered and reported to the National Assembly and to the public. In the digital age, the rule of law must evolve from relying solely on the conscience of legal professionals to a system that uses data and algorithms to warn of inequality on its own. This is the new rule of law architecture that emerges from the combination of FEA and relational philosophy, civic literacy to protect the system, awakening ignorant, incompetent, and self-seeking citizens. First, when I describe citizens as ignorant, incompetent, and self-seeking, it is not to insult the people. It is a warning meant to confront the fact that our system, education, media, and politics have left citizens in that state, because law, punishment, and the judicial system are seen as difficult and complex. They have been left to the experts. In the meantime, Korea has become a country where the powerful and the conglomerates enjoy a paradise on earth, where legal elites preside over a republic of law, and where false and distorted rule of law falls hardest on ordinary people and the poor. Civic literacy begins with the recognition of this reality. Second, from now on, citizens must become not guests of the system, but its architects. You must ask, for whom do the Republic of Legislation, the Republic of Trials, and the Republic of Lawsuits truly exist? And why is it that conglomerate leaders and those in power so often avoid detention while the poor see their entire lives collapse over a single fine? The more frequently such questions are asked, the less able the National Assembly, the judiciary, the law firms, and those in power will be to avert their eyes. Third, liberal democracy is not preserved by elections alone. It requires citizens' eyes that can read the structures of power contained in a single judgment, a single fine notice, and a single complaint. We need citizens who demand changes to laws that punish only the poor twice over, that are lenient only toward the powerful and the conglomerates, and that enrich only the legal elites. When citizens grow from ignorant, incompetent, and self-seeking individuals into people who understand relationships and participate in designing the system, then and only then can the rule of law in Korea be set upright. Fourth, I sincerely hope that today's commentary does not merely inflame anger, but becomes a turning point that transforms anger into energy for changing the structure. By holding in our hearts the question, a law that punishes only the poor, can this be fair? And by becoming citizens who act to transform the Republic of Legislation, the Republic of Trials, and the Republic of Lawsuits, we can protect our system. At the end of that path, Korea will no longer be a country that is heaven only for the powerful and the conglomerates, but a liberal democratic nation that is fair to everyone. Thank you for watching Professor Lee Nam-yong's long-form commentary.